So first of all, welcome to all of my new YouTube subscribers. I know this has been a lot of information on this page, but we're going to talk about the borrower's defense application. If you are new to me, my name is Tammy. I am the owner of Tammy A1 Consulting, and I do a variety of things. My main thing is educating, and what I like to do, not only with educating, but also teaching student loan borrowers, also those who are dealing with issues with their credit, on how to advocate for yourself, how to protect yourself, and how to understand your rights. And then also with all these different applications that are out here, just to kind of help borrowers get a better understanding of how to complete applications or things to look for in these applications. And like I said in the beginning, we're going to talk about the borrower's defense to repayment application. I've been getting a lot of messages about this application. I know that some of you are still struggling with the application, but today I'm hoping I can make it a lot easier for you to get your application submitted. There's a lot that's going on with federal student loans, and this program is one of the things that may be on the chopping block as far as how long it's going to take for borrowers to get their loans discharged, and then if the program is still going to be around as far as in what capacity. So let's talk about it. So what you see behind me, because most borrowers who learn about borrower's defense is through the Sweet versus Cardona settlement. You've seen this list of schools, this huge list of schools. There's well over 100 plus schools that is on this list. And a lot of you see your school as one of those that are listed. But let's talk about the Sweet versus Cardona settlement. So that way it's clear that if you are a student loan borrower and you have attended one of the schools that were included in the Sweet settlement, how you can actually use this information to help you with submitting your borrower's defense application. Now, this settlement is closed. This settlement was closed as of November 16, 2022. So if you submitted an application as of today, right now, then you were not privy to any of the clauses that were in the settlement. You will be submitting your application on an individual basis unless that application is pulled into some type of class action lawsuit, okay? I'm gonna try to make this video as short as possible. I have a cheat sheet on my website where I do the same type of video where I walk you step by step through the application. Not only that, I provide you with information to get your verbiage together and then also to help you to be able to state a claim, because it's important that you do that when you're submitting your application. It also helps you with finding supporting evidence and then also evidence of your own. So let's get started. So with the Sweet versus Cardona settlement, and the one thing I want to make clear, if your school was on this list, you are not privy to any of the clauses of the Sweet settlement. Your school being on the list does not mean that your student loans are going to be discharged. If you actually read the complaint under the Sweet settlement, the complaint was not against the school per se. The complaint was against the Department of Education and how they were handling borrower's defense applications, how they were not responding or making decisions without providing explanations or not necessarily making decisions, but the lack of decision making and then or denying applications without allowing borrowers to have due process or providing them with an explanation on why the application was denied. But here on the Student Aid website, so you can just go to studentaid.gov, all the information about borrower's defense is going to be right up under loan forgiveness. When you go to loan forgiveness and you just click on borrower defense to repayment, it will get you to all the information that you need to access the application, and then also shows you how to submit an application that is defined as materially complete. Okay, so when we get to the Sweet settlement, and like I said, if you have not read over the Sweet settlement case, I advise you to, especially if you're trying to use this to help. So it tells you about what happened on the 22nd of June, 2022. ED and the plaintiffs reached a settlement in the case titled Sweet versus Cardona, formerly Sweet versus DeVos. The court granted final approval to the settlement as fair, adequate, and reasonable on November 16, 2022. So this is the date. If you've submitted an application after this date, then you're not part of the class, which means you're not a class member or post-class member in this particular settlement. It tells you the agreement affects the processing of borrower defense applications filed on or before November 15th. Borrower applications for borrower defense discharges were pending as of June 22nd, 2022 are class members, while those whose applications were submitted in the period from June 23rd to November 15th, 2022 are post-class applicants. The settlement became effective on January 28th, 2023, and ED is starting to implement it as described below. So it's already in process. A lot of the class members, if not all, of the class members have already received full discharge and also refund of their federal student loans as under the settlement. But of course, with this settlement, this has not been an easy thing. These borrowers have had to go back and forth in court to get their loans discharged. So as of now, there was actually just a court hearing just last month because of the Department of Education not obliging by the terms of the settlement. But it tells you more or less what the case is about. It tells you what the terms of the settlement was. Also, this is where you can see the list of schools that are attached to the settlement. So this is for those of you who attended any of these schools that is on this list. Now, what that means for you now, there are some schools on here that, even though they were in the Sweet settlement, the Department of Education took separate actions against the school, where there was a bunch of borrowers who attended certain schools even though they were in a settlement, but the Department of Education also came in and discharged a bunch of borrowers at certain schools during certain periods of time. And for instance, one like Ashford University, which is one that was just recent, they discharge a whole lot of borrowers. And you can see more information about that on the student aid website. But this is the list of schools. You're able to see all of the information here where it shows you all of the schools that were a part of the settlement. Now, remember, the settlement, the complaint is not against the schools per se. The settlement is against the Department of Education, or the complaint is against the Department of Education and how they were handling borrowers' defense applications. Now, that doesn't mean that although the settlement, the complaint, was not necessarily against the schools, but we know that in order for these schools to be on the list, and there's a complaint that is out there. So if you are a borrower and you took out federal student loans to attend any of these schools that is on this list, then that means that you got some supporting evidence out here to assist you with your application, okay? Because that's all it's going to be, is supporting evidence or supporting documentation to help assist with your claims. That's just more or less to back up what you're saying, what your allegation is. Like basically they say, see here, this is what everybody else is. It's not just me. There's other borrowers who have experienced this as well. So that is what this information will now do for you when you are looking for information to help you with your borrower's defense application. And in my cheat sheet, I show you exactly how to find all of that information. Okay, so let's go to the borrower's defense application within itself. Now, just like I said, you can go back to loan forgiveness and you want to go. So go to loan forgive, if I can get there, go to borrower defense to repayment. Okay. And once you get here, this is where it's going to give you all the information. You get updates about borrower's defense, how to apply. This is where when you already start the process of your application, this is where you can go to manage the application. Download the PDF. I recommend everyone, and we're going to go to this PDF application to read the application prior to you submitting it, so that way you can get an understanding of how long it's going to take. They tell you who should complete this. Under the 2023 regulation, borrowers who have federal student loans and can demonstrate that they enrolled in a school or continue to attend a school based on misleading information from the school or other misconduct covered by the regulation and suffered a detriment that is of a nature and degree warranting a full discharge of their applicable federal student loans. Say application takes about 3 hours, you will need the following information or documents. So they tell you what all that you need: the name of the school and program, your enrollment dates, documentation to support why you believe you qualify for borrower defense, and demonstrate the harm you suffered. So here's where they speak about, as of August 7, 2023, there is an injunction against the latest borrower's defense regulation that was published on November 1st, 2022. So under this injunction, what that means, because when it comes to when your loans were dispersed, there are certain regulations that are connected to it. And under those regulations, it will also govern how your or how your application is going to be judged. And here's where they talk about, under this particular regulation that was released, or that there's a stay against it, which means they're not going to be discharging any loans that fall under that particular regulation. They're not going to be discharging loans under that one. It won't be your loans, your application will not be scrutinized under that particular set. And because it was generous. And if you go read on how they were going to discharge the loan, then you'll be able to see why there were certain states who were just like, absolutely not. It's way too easy. Because at the end of the day, when these loans are discharged under borrower's defense, the money has to be recouped some way, shape, form, or fashion. And usually what happens is the Department of Education will go after the school, go after the institution who is the subject of the claim. And because when you look at these lawsuits, the majority of these schools are not admitting any fault. They're not saying, yes, this is what I did to borrowers. They're not saying that. But even still, there has to be money that's recouped. When a loan is discharged, somebody has to cover it. So that's what happens. And when there is regulations that are in place that allow the Department of Education to go after a school to recoup the money from a loan that is discharged, and you have that kickback. Okay. All right. But this is all the information that you need. Also, it tells you to read findings on how the Department of Education used to approve borrower's defense claim, recent borrower defense announcements. Okay. So you click here. All right. And this is where you will be able to see all of the information more or less about the injunction that is against the 2022 or 2023 rule regulation. But here, these are all additional schools, and some of these schools were on the Sweet vs. Cardona list. This is where you can go read about these other schools where the Department of Education has discharged the loans. Not only that, this is information that you can utilize to help support you in your application. If you were someone that did not fall into either the date, because for some schools, it was connected to a certain time period. So let's say that you went to the school, maybe it wasn't during this time period, but it was around that time period. You have this information here to help support you. Some of you have a discharge that should have been applied. You may not have got it. And sometimes it happens when there is not an application that has been submitted. There are borrowers who get overlooked, you get skipped. So if you see your school here and you see that there was an entire class action lawsuit where the entirety, depending on if it was years upon years that they discharged and you fell into that and you didn't get a discharge, then you would definitely want to, get your application submitted in order to get your discharge. But it tells you all of the information you need here, and it'll show you all of the dates and everything that you need to know. Not only that, you can read the press release. So even if you didn't fall into any of the dates or the timeframes, but you attended this school, this is information that you can use to help support your claim, okay? Even though this is not going to be the basis, if you fall outside of the dates, it's not going to be the basis of your application or of your claim, but this is information that can help support your claim when you submit your application. But yeah, go make sure you go back and look at this information here. Let's go take a look at the application within itself, okay? Now to get to the application within itself, I'm sorry, I don't want to hurt anyone's eyes. Let's go back here. We'll go back to loan forgiveness and we'll go to borrowed defense to repayment. All right, and this is where you hit that download PDF. And when you hit download PDF, that is where you're going to get the actual borrowed defense application, okay? And it's important that you read this application, y'all. The instructions tell you everything that you need to know about completing this application successfully, okay? So let's get started with the application. And in my cheat sheet, I walk you step by step through this entire application and the instructions. Because when we look at the application, we know that just reading the instructions alone, that this institution, the Department of Education, they already know what has been taking place just based off of the information that's just in the instructions, okay? But it tells you, you may be eligible to receive a discharge of your applicable federal student loans if the school that you attended or that your child attended if you are a parent plus borrower committed certain misconduct. So what that means, if you are a parent plus borrower and you took out student loans for your child who attended one of these schools, and let's say your child received a discharge of their student loans and you did not, you can put your application in, okay? This is called a borrowed defense to repayment discharge. The regulations that apply to this kind of situation are the borrowed defense to repayment regulations. It's important that you understand the regulations as well. And in my cheat sheet, I actually have for each one of these, and I'll show you really quick. For each one of these, each section here, I've actually already embedded each of the law sections, each of the regulations beside each one of these, so you have a clear understanding of what everything means, because everything has a definition, okay? All right, so let's go back to the application. All right, if you believe that you may qualify for a borrowed defense to repayment discharge, you should complete this application. It outlines the type of misconduct by the school that might qualify you for relief. Once you submit this application, this tells you what happens after you submit the application. The Department of Education will review your allegations. They're also going to ask your school to respond to your claims. Then ED will consider your application, any additional evidence you provide, any evidence in their possession, and any response received from your school. A lot of borrowers think that because their schools are closed, that they don't have to do their best or put in as much details with their application as possible because you're dealing with a closed school. Well, there's still lawyers and things of that nature that these schools may have, and funds and things of that nature, even in bankruptcy, that may still be available, that people are still overseeing. So when you are seeking a claim under borrowed defense, even if your school is closed, you want to make sure that you're as detailed as possible in this application when you are making these allegations. Not only that, providing as much evidence, not only just supporting evidence, but also evidence of your own, which means you want those catalogs. But also, y'all, a lot of people just get caught up with providing evidence. You want to make sure that the evidence doesn't work against you as well. So sometimes in these catalogs, the information is in catalogs that tells you the exact thing that you may be putting a claim in. So you want to make sure that your claim, makes sense, that you're not, that there's not something that's in the catalog, or in your enrollment documents or things of that nature that you have signed for, and maybe you didn't read, but you were informed of it and maybe just didn't, weren't aware. So that's another thing too, with requesting documentations as well. So that way you'll know exactly, what you signed for. And I know for a lot of borrowed schools are closed, so getting access to those documents can be a little difficult. But we do have, there are avenues that are available for you to request information directly from the Department of Education. You can do that through the Privacy Act and also the Freedom of Information Act as well. And that's all, that's all information online. And I got information about that as well if you need it. Okay, so ED strongly, oh, I missed the spot. ED will notify you when the review is complete and the decision has been made. ED will generally make a decision on your application within 3 years from the date your application is determined to be materially complete. For more information, please visit the Borrower Defense website. Now, mind you, under Borrower Defense regulation, there is no time frame, in a sense, on how long the Department of Education has to make a decision on your application. And I know a lot of borrowers, when we see this 3 years here, remember there's a stay against the regulation for 2023. So when we see this 3 years here, a lot are like, okay, 3 years from the date, they put this application in, but there's a word here that a lot of borrowers overlook, and that's when they determine it to be materially complete. And it's important that you understand what exactly does materially complete mean. So like I said, everything in here has a definition. There's a meaning to every single one of these sections here in the application, and you have to be aware of that, okay? So the Department of Education, they tell you what a materially complete application is, and you can look at that by going to the Student Aid website. So let's go there and take a look at that really quick. Okay, let's X out of here. And we're gonna go back to, the Borrower's Defense. And right here is where it tells you, learn how to submit the strongest application possible. Because that's what we want, right? We want the strongest application possible. But even with the strongest application there is, it does not mean that they're going to discharge a loan. And it's very clear in here, okay? They tell you what is Borrower's Defense and should I apply. They tell you what it is, legal ground for discharging federal student loans. Under the law, you may have a Borrower's Defense repayment if your school engaged in certain misconduct related to the making of a federal loan or the educational services it provided which cause you harm, warranting a full discharge of your applicable federal direct loans. If the Department of Education approves your application for Borrower's Defense, we will discharge any remaining balance on the federal student loans when you took out to attend the school, and may also refund loan payments you already made. Borrowers must submit applications under the penalty of perjury that an application is accurate and true to the best of their knowledge. There's no need to lie on these applications, y'all. Everyone who attended one of these schools, no, you may not have been harmed. And if this application does not apply to you, then you don't want to submit it. So we want to be truthful in the application, okay? If it didn't happen, it didn't happen, all right? One thing to remember, the Department of Education did not guarantee a quality education. So even with the taking out these federal student loans, just the act of having a federal student loan does not constitute harm as under Borrower's Defense, okay? Parent Plus borrowers are also eligible for Borrower's Defense if the conduct described above occurred to their child. Parent Plus borrowers must submit their own application and may submit an application even if their child does not. Before you apply, read this important message. Under the 2023 regulation, your Borrower's Defense application must be materially complete for ED to consider your application. Please review materially complete standard and how to write your claim sections below to make sure your application is materially complete and to learn about additional information you must include. If your application is not materially complete, it will be denied, okay? They tell you reasons why borrowers apply for Borrower's Defense. Do I have to submit an application to receive a discharge? And this is what I was talking about earlier, how some borrowers may have been overlooked when there were class actions or group discharges. So it says, if you think your situation qualifies for Borrower's Defense, you should submit an application. In some instances, ED has discharged loans for borrowers who didn't apply for Borrower's Defense. However, we can't guarantee that similar discharges will be extended to students of any particular school. Therefore, it's best to submit a detailed application if you believe you qualify. So what that means, if you are someone who fell into one of those discharges that the Department of Education has completed, and you got overlooked, and you want to submit that application, and that is what you want to include in your application, like, hey, the Department of Education, you discharged these loans during this amount of time. I attended. Provide your supporting information, your documentation of when you attended, all of that, your transcripts, all of that information, and then also with a copy of the information that I showed you guys previously, where you can attach that information about the school if that happens to you, okay? All right, they tell you what your eligibility is, the kind of misconduct that may qualify for Borrower's Defense under the 2023 regulation. Now, mind you, this regulation, there's a stay against it, which means that they're not going to be discharging any loans under this particular regulation as it stands right now, as things work its way through the courts, and it's been in since 2022. So we'll see what happens with this. But this is the way the application still must be submitted. They tell you what a substantial misrepresentation, omission of fact, breach of contract, aggressive and deceptive recruitment, judgment against your school, and prior secretarial action. So they tell you all of these ways that you can get your loans discharged. And mind you, there's regulations for each one of these as well. And in my cheat sheet, I give you all of that information. It'll be all beside, so you know exactly what information to take a look at, okay? All right, but let's go back. Okay, so let's say anything, if you've already paid off your loans, then unfortunately you wouldn't be able to apply for borrower's defense because there has to be an outstanding balance in order for you to put this application in. If they're already paid off, then there's nothing to discharge, okay? They tell you what to do before you apply. Decide what information you want to include. Download the application. Understand the types of conduct listed in the question, kinds of school misconduct that may qualify for borrower defense discharge. Determine what type of conduct applies to your situation and outlining and organizing the facts of your claim. They tell you about gathering documents. Try to provide as much documentation as you can, such as documents that support your claim that your school lied to you or misled you, such as emails, other communications between you and your school, course catalogs, student handbooks, advertisements from your school, such as web ads, social media ads, email ads, print ads, or YouTube links to television ads. So you can even put YouTube links into your as part of your supporting evidence, okay? Documents that confirm the dates of your enrollment of program or study, such as enrollment agreements, transcripts, and diplomas. And for those of you who have attended a closed school and you're not able to get your transcripts, in my cheat sheet, I have information on how you can get that transcript, okay? A copy of your contract with the school or a copy of the court's judgment or opinion if you're making a claim based on breach of contract. They tell you here, what is the materially complete standard? And this is what the application must be formatted in order for you to have your loans considered for discharge. The 2023 regulation has a materially complete standard. Your application must be materially complete to be considered, not to be approved, just to be considered, okay? If your application is not materially complete, your application will be denied. Just because your application is considered materially complete does not necessarily mean it will be approved. And they tell you in order to be materially complete, a description of one or more acts or omissions by your school. The school or school representative who committed the act or omission. Not everyone remembers who they talked to. You know, it may have been a female or a male recruiter or something like that. You necessarily have to know the name of the person. You just want to be able to tell the story. And as we continue, you'll see how they want a story, but when you get to the actual live application and you're submitting it online, you're only allowed 2,000 character spaces. So although, yes, they want detailed information, but you're limited to what you can tell as well, okay? But approximately when the act or omission occurred. Now, approximate is not exact. And in the actual application, they'll ask you, is the information approximate or is this exact? So even though if you're not for sure on specific dates, you do know attendance where there were seasons. So you can say the fall of 2023 or the summer of 2023, whatever the thing was, in order to give them a context of when things took place. Even if you don't know if it was May 14, 2022, you know, you don't have to know the exact date because it doesn't say exactly when, it's just an approximation. How the act or omission impacted your decision to attend the school or continue attending or take out the loan for which you are asserting a defense. So it's important that we read these things because some borrowers, this may have happened after you had already enrolled. They could have been providing you with misleading and false information, or not providing you with the information at all, omitted important information to get you to continue your enrollment at the school, which means you still took out additional student loans, but you were already enrolled in the school. And this is where the deception came after you were already in the school. A description of the detriment you suffered as a result of the school's acts or omissions. This means you need to explain what the results of the school's misconduct was, specifically what harm you experienced because of the misconduct. Now, a lot of bars, when you see the word harm, some will get caught up in, and don't get me wrong, emotional harm, all those things are extremely important because it's a lot of stress when you have went to a school and you are now stuck with a useless degree. It's a lot. But in the terms of the Department of Education, they want to see how you were financially harmed by taking out these federal student loans and attending this school that may have misled you or deceived you or defrauded you, whatever the case may be, or omitted facts from you or misrepresented themselves. And they actually have a regulation. They actually have a definition for financial harm under the regulation. I'm going to show it to you guys. But they tell you what the materially complete claim under the 2023 regulation. So this is what they consider a materially complete response. After my in-person campus tour in June of 2018, so remember, we don't have to be exact, just an approximation. John Franklin, my recruiter, told me that the school had a job placement program that was guaranteed to place me in a job after I graduated. I mainly wanted to go back to school because I wanted to start a career, so this sounded great. I visited career services multiple times before and after graduation, trying to get a job placement, but they never placed me in a job. I never would have signed up if I knew the truth. I remained jobless for 6 months and eventually had to take a minimum wage job that didn't require my degree. I now have a mountain of loan debt that I can't afford with the jobs that I can be hired for. This is what they consider a materially complete response, and they tell you why. Under the 2023 regulation, this is considered materially complete because of these reasons. The bar explains that what the school said or represented. The school had a job placement program that was guaranteed to place me in a job after I graduated. The bar explains who provided the information. John Franklin, my recruiter. You may not know the name of your recruiter, but a male recruiter, or just your recruiter, or the financial aid advisor, the tour guide, whatever the case. And not everyone misrepresentation actually came from a human being. Yours could have been through an ad or through the brochure, their material. So not everything came from an actual human. All right. The bar explains when this conduct occurred after my in-person campus tour in June of 2018. The bar explains why the information provided was important to them when they enrolled. I mainly wanted to go back to school because I wanted to start a career. The bar explains how the school's conduct harmed them. I remained jobless for 6 months and eventually had to take a minimum wage job that didn't require my degree. I now have a mountain load of debt that I can't afford with the jobs that I can be hired for. But you know, if you really look at this, this is all financial harm because you were jobless for 6 months. You took a minimum wage job that didn't even require a degree. So now the degree is useless. I now have a mountain load of debt that I can't afford with the jobs that I can be hired for. So although we talked about the harm that was caused, and in this particular example didn't go, I was stressed out the entire time. I couldn't eat, things of that nature. We see exactly what type of harm it is that they are centering this around, and it's more financially, okay? Because if you can't get a job, then I can't make any money. If you're working a minimum wage job and you have a degree that you were guaranteed to go out here and make hundreds of thousands of dollars for, and you're at a minimum wage job, now I'm financially harmed. I can't pay my bills. I can't provide for my family. Now I have a mountain load of debt that I can't afford with the jobs that I can't be hired for. I'm stuck with all the student debt based off these promises that were made for me to make this $100+ thousands of dollars upon graduation, and that wasn't the truth. They misrepresented themselves. They lied to me about those about that job or the prospects or whatever the case may be, and that is where their harm comes in. This is what's considered a materially incomplete response. They told me that they would teach me everything I need to know to become a hairstylist. I learned some things, but I feel that it was not that great. They tell you under the 2023 regulation, this example is not considered materially complete because of these reasons. There was no explanation of who made the statement or representation. They did not explain when and where this conduct occurred. We can't tell whether the statement was made during enrollment, after enrollment, or at another time. We can't tell if it was made on a phone call, through an advertisement, or in person. The bar does not explain why the information provided was important to them when they enrolled, and the bar does not explain how the school's conduct harmed them. So we know they want a story. They want to be able to tell the setting because, mind you, for majority of these schools, there's already other complaints from other bars. So I have not seen a school yet where there was not another student who attended where there was not some type of complaint about the programs that they attended or just the school in general. So the Department of Education, they already have information about these schools. So this is why they want settings, so that way they can line these things up to see what other bars are talking about, okay? They tell you how to write your claim. And when you get into the actual application, this is what you're going to see for each allegation that you have against the school. And mind you, you only need one allegation, okay? More allegation doesn't mean that your application is going to be approved, because you want to be able, if there's just one thing that the school did, then you just want to make sure that you're as detailed as possible with that one allegation. If the other things didn't happen, then you don't utilize it. But each allegation is going to ask you what was said, who or what provided you the information or concealed the information from you. Include the person's name and title if known. So remember, like I said in the beginning, you don't have to know their name. But of course, if you know it was a recruiter or the financial aid advisor or whatever the context was. When and where did this conduct occur? The approximate date or time of year, and whether it was during a campus tour or interview, in a meeting, or over the phone. How was the information communicated to you? Via email, in person, through an advertisement? How was the information deceptive or misleading? And how did you determine that the information was deceptive or misleading? And a lot of bars didn't find out until the sweet settlement came out. You may have had a feeling, but a lot of bars were not aware until this settlement came about that, wait a minute, I was deceived. I may have had a feeling, but it wasn't until this lawsuit came about that you realized and you started doing the work to go look at your documents to see what took place. And now you have the understanding why you never got that job after all of the time going down to career services or reaching out to your advisor to get assistance, or whatever the case may be, your professors in your classroom not providing you information, or because they're all representation of the institution. So everybody that you come in contact with, that's just what you want to think about. What was told to you through everyone that you came in contact with, not only just the people, but also the information that was provided. That's why it's important to go through your documents to look at those. Why was the information provided to you or concealed from you important to you when you enrolled? In what way did it influence your decision? So you think about that, the information that was provided to you, the reason why it was important, because if you were promised a job at a certain company or you was going to make a certain amount of money, that is extremely important to you, because that's telling me that I don't have to worry anymore. I can provide for my family. If I know that by completing this program that I stand to leave this school, guaranteed a job to work at one of the top businesses, top companies somewhere, and I don't have to worry anymore. You have that freedom of just, and at that point, if someone has made promises to you, you don't care at the end of the day what it takes for you to get there. And as far as taking out these loans, it's not even a second thought on what you have to do, because you're not concerned about the loans at that time, because you're going to be making enough money to pay them off, but only to find out later that it was all, a lie, or they concealed, important information from you, like, hey, we don't even have a relationship with these companies whatsoever. So, so things like that. How did this conduct harm you? The borrower's defense application will guide you to answer these questions, and they tell you more or less about all the information, okay? All right, and you go back and read that information. But going back to the application, all right, they give you the type of conduct that can lead to an approved application. You may qualify if the school or its representatives made untruthful or misleading statements while trying to convince you to enroll or to remain enrolled. And we talked about that. You have to show the information was important to you when you decided whether to enroll or remain enrolled. You also have to show that the misconduct caused you enough harm to justify a full discharge and refund of all your federal student loans. They give you all of the areas here: the employment outcomes, school educational programs, the financial charges. Not only that, they tell you what must be in the application. ED can only consider complete applications to be complete and must include at least the following information: a description in your own words of the statements, acts, or omissions that you believe qualify you for borrower's defense, an explanation of who made the statements, acts, or omissions, or how they were made and in what context. Make sure that we are reading each thing, okay? Because this can sometimes get you tripped up, because there's so much in just one sentence. An explanation of who made the statements, acts, or omissions. Remember, when you see the word or, we got a choice, okay? When we see the word and, that's something in addition to it. So that means that there's something in addition to this that we need to provide, okay? Now, so those are the things that you want to pay attention to, because one thing they're looking for is to see how reliant you are in the application. And if you're submitting information and it's not complete, then you don't want your application to be denied because you didn't, pay attention to what it is that they're saying, okay? All right, so a description of the harm you suffer because of the school statement's act or omission. ED recommends you provide as much detail as possible in the section below about the statement, act, or omissions that you believe qualifies you for a borrower defense to repayment. Additionally, they recommend that you include the following documents: documents that support your claim that your school lied or misled you, including any email. So again, they just tell you about the documents that you can provide. Documents that support your claim that there was a judgment against your school, including a copy of a court's judgment, if available. Documents that support your claim that your school breached a contract. Documents that show the dates of your enrollment in your program of study, including enrollment agreements, transcripts, and diplomas. Again, any other documentation that is related to your reason you are applying for borrower defense relief. So any other supporting documentation that you have, you want to provide that information. Now, mind you, when it comes to the sweet settlement, okay, because a settlement is not a reason for discharge under borrower's defense, and that's actually here in the application. As you go down further, and also remember too, when you get to the actual live application, you're not going to see all of this information, okay? So I know that this can be overwhelming when you look at the application. When you go into the live application, you're only going to see what you're accusing the school of, what the allegations is for the school. And you want to make sure that you read each one of these, okay? Read each one of them to see what is applicable to your situation, okay? If there's more than one, do you want to provide it? Because like I said, you're going to be answering the same thing: the who, what, when, where, why, and how. And some of the time you may overtalk yourself. You may actually answer the question in the who section, or you may answer the question in the how section, but that's okay. You still want to be able to tell the story. And like I told you, you get 2,000 character spaces in each one of these boxes, and you want to make sure you fill up those 2,000 character spaces, because remember, they want a story. So you want to be able to tell that. And in my cheat sheet, I show you how to fill those spaces up, okay? Right here, a settlement does not qualify you for borrower defense or relief, even if the settlement was favorable to you. A settlement agreement is not a favorable judgment for the purpose of borrower defense relief. So that is why those of you who have attended a school that is a part of the sweet settlement, if you are not a class member in that settlement, then you're not going to use that settlement as the basis of your claim. You can use it to support your claim because we have your school was included in a settlement or was mentioned in a settlement. But not only that, if your school was included in this settlement, then there's going to be some supporting evidence. There's going to be some other complaints out there, and those are the things that you want to provide. But the sweet settlement is not going to be the basis of your claim because you're not a member of that settlement, and so you're not privy to anything under it, okay? Another thing to remember, this harm section, and this is where I want to show you guys what financial harm is, okay? Because you got to be able to explain that. Here, you have the option as well. If you are someone who while they're making a decision, you can put your loans in a forbearance. You have the option to put your loans in a forbearance, but I never advise anyone to put their loans in forbearance if you don't have to. If there's an income driven repayment plan that you qualify for, because a lot of borrowers qualify for, and I know there's a lot that's going on in the courts right now with the injunction against these repayment plans, but you always want to make sure that you look into an income driven repayment plan before you go into a forbearance option. But that is an option for you to put your loans into a forbearance until a decision is made on your application. But just know, if that application is denied for any reason, then they're going to start resuming the collection of the loan. Even if you are in default, you're able to put your loans into a forbearance under borrower's defense, okay? All right, so here it tells you what you are certifying to. Make sure that you read all of this. So that way, what you know that you have an understanding of what you're certifying to by submitting this application. More or less, there's that Privacy Act notice. Remember, I said in the beginning of the video that you're able to request information from the Department of Education under the Privacy Act. And there's information about that, okay? All right, but let me show you what harm is, okay? Because I want you guys to have an understanding of what that is. All right, and like I said, in my cheat sheet, this is a document that is in there. So that way you're not looking all around for it, but you can always go to the regulations for borrower's defense and you can get there just as well, okay? So we're gonna go to Cornell Law, okay? And this is here 34 CFR 685.206, and this is your borrower responsibilities and defenses. So this is what you want to read over so you understand what your responsibilities are as a borrower and what defenses you can use when you're you're stating a claim under borrower's defense discharge. But they tell you as well, because in the beginning of the video, I talked about how your loans are dispersed. And under the disbursements, it tells you how your application will be judged, because the 2023 regulation, there is a stay against it. So they're not discharging loans under that particular regulation until it works its way through the courts. But some of you may be able to have a claim for borrower's defense under state laws as well. We have unfair, deceptive practices that you may be able to also put in a claim against. And in my cheat sheet, I talk about that and how to put that information in your application, okay? But let's go down, because I want to show you when they talk about financial harm, what it actually means. But they give you, this is where our definition starts. They tell you what a misrepresentation is and all of that, and what evidence you need to provide. So all of that information is here. But this is where they talk about financial harm, okay? And under this paragraph, financial harm is the amount of monetary loss that a borrower incurs as a consequence of a misrepresentation as defined in paragraph E3. And that's just what the definition is for misrepresentation. Financial harm does not include damages for non-monetary loss, such as personal injury, inconvenience, aggravation, emotional distress, pain and suffering, punitive damages, or opportunity costs. The department does not consider the act of taking out a direct loan or a loan repaid by a direct consolidation loan alone as evidence of financial harm to the borrower. Financial harm is such monetary loss that is not predominantly due to intervening local, regional, or national economic or labor market conditions as demonstrated by evidence before the secretary provided to the secretary by the borrower or the school. Financial harm cannot arise from the borrower's voluntary decision to pursue less than full-time work or not to work, or result from a voluntary change in occupation. Evidence of financial harm may include, but is not limited to, the following circumstances: periods of unemployment upon graduating from the school's program that are unrelated to national or local economic recessions, a significant difference between the amount or nature of the tuition and fees that an institution represented to the borrower that the institution would charge or was charging, and the actual amount or nature of the tuition and fees charged by the institution for which the direct loan was dispersed or for which a loan repaid by direct consolidation loan was dispersed, the borrower's inability to secure employment in the field of study for which the institution expressly guaranteed employment, and the borrower's inability to complete the program because the institution no longer offers a requirement necessary for completion of the program, in which the borrower enrolled, and the institution did not provide for an acceptable alternative requirement to enable completion of the program. So this here kind of goes into closed school discharge as well. A lot of borrowers can seek discharge under closed school. Under closed school discharge, that more or less goes in line when a school closes and there's not a program that they don't offer another program suitable for the borrower to transfer into. So that's more or less of that, but I won't go too much into that. 5 here tells you what things are excluded. So these are things that if your basis is these particular things, these are things that are excluded, okay? The secretary will not accept the following as a basis for a borrowed offense repayment under this paragraph: a violation by the institution of a requirement of the Act or the Department's regulation for a borrowed offense to repayment under paragraph C or D of this section, or under, and they give you the regulation here, unless a violation will otherwise constitute the basis for a successful borrowed offense repayment under this paragraph, or a claim that does not directly and clearly relate to enrollment or continuing enrollment at the institution or the provision of educational service for which the loan was made, including but not limited to. All right, so these things here: personal injury, sexual harassment, a violation of civil rights, slander or defamation, property damage, the general quality of the student's education. This is one thing here that I see a lot too. Borrowers are like, well, I don't feel like I got a quality education. Well, if you read your master promissory note, it is not something that's guaranteed under your master promissory note. So trying to put in a claim just based off the quality, now don't get me wrong. These are things you can speak on, but if this is the basis, then this is something that's excluded. Or the reasonableness of an educator's conduct in providing educational services, informal communications from other students, academic disputes and disciplinary matters, and breach of contract unless the school's acts what otherwise constitute the basis for a successful defense to repayment under paragraph E, okay? All right, so you can read more about, as far as more information about borrower's offense, about forbearance, all of that information here, okay? All right, so let's go back. Okay, so that's basically it for the application. Like I said, just become familiar with the instructions. The instructions are extremely important. Reading the instructions will tell you everything that you need to know. Once you start getting down to this section, the conduct that may result in a borrowed offense approval, more information that's extremely important. They tell you the following are common categories of misconduct alleged, and this is what I said in the beginning. They know they already have information about other borrowers who have put in borrower's offense application. They tell us that the following are common categories of misconduct alleged by borrowers, including some specific examples. You should only check the boxes that apply to you. Please select all that apply. If none of the categories apply to you, there's an other category at the end of this section. You see that word must, which means this is something you have to do. You must write out answers to the questions that follow the checkboxes in the space provided. The questions request additional information describing the misconduct, including information like what occurred, when it occurred, how it impacted you, and other details necessary to consider your application, okay? And that is where you start getting into the allegation. So make sure you read every single allegation thoroughly, see which one applies to you. Make sure that you are answering each section. And some of these may have 2 parts, and you don't want to miss what did the school say, right, or conceal, suppress, or omit from you. When we see we have a 2-part, please be as specific as possible. What did the school's actions lead you to believe? So you want to just make sure, like I said, that you're reading these sentences through, because some of them may ask you for more than one thing in a sentence, and you don't want to miss anything there. As far as your enrollment dates at the school, month, year to year, this is other parts that they're going to ask you about in the contact and your school information. Here's another thing I see a lot of borrowers that miss. In what states did you live during enrollment period that is the subject of the claim? Another, please include the month, year when you lived in each state. So you want to make sure that you're providing that, because like I said, they're looking to see how reliant you are. And if you are missing parts on the application, it's a reason for them to deny it. And not only that, it gives their legal team, reasons to say, hey, I need more information about that. And the last thing you want to do is to have an application sitting for years and years to have it kicked back because of something small that you overlook. So take your time with the application, make sure that you read it. There's another document as well that that I have added to the cheat sheet. And this is something too, where it's another important document. And this is a document that came out in 2021. And basically with this document here, and it's an extremely important, it's really informative as well. So what this is it just shows you how the Department of Education, what their decision-making process is like. And one thing in here, they talk about stating a claim for you to be able to state a claim. And that is something that I actually have in the cheat sheet as well. I wrote the entire sheet up. All you do is plug in your information and, change things where you need to. But it's important that you look at this document here, and it tells you how how the Department of Education, how to review a borrower's allegations. So this is what you want to do. Did the borrower allege an act or omission by their school? And they tell you all of this information here, which was wild to me when I read it, but they even give you examples like, so this is a document that's in the cheat sheet. You want to read this as well. It's wild, y'all. So yeah, but all this is on my website, and my website is just my name, Tammy A1 Consulting LLC.com. And you can get the cheat sheet. I also do one-on-ones for borrower's offense as well, y'all. But I appreciate everyone who are new subscribers to my website. I'm still trying to grow this channel. But yeah, all right, good luck with everything, you guys. Let me know if you need any assistance, and I'll be glad to help.